With the first session, the first act of which is the keynote speech of Professor Berlingieri. It will be introduced by the co-chairmen of the session, who are Mauro Guerra and Federico Deodato. Just an information, in the other room there is a big screen, perhaps later are other people coming, they can stay there. But there is also a service of simultaneous translation. So if everybody wants to check, I can see nobody has got the but if anybody wants to check how efficient this is, the interpreters are very good, but we would like to listen to them. Is welcome to take some headphone and listen to it. So I ask Federico Deodato and Mauro Guerra now to chair the rest of this session, please.
Thank you, Francesco. Good morning to Mr. President D'Amico, to Professor Berlingieri, all distinguished speakers, panelists, ladies and gentlemen. Welcome to this third edition of Shipping and the Law. And it's a great honor for Federico Deodato and myself to chair this morning section that will be opened by Professor Berlingieri. We are 12 speakers and 12 panelists, so the role of Federico and myself will be just to control that we'll keep the timing within the frame allowed to any of the speakers. We will try to speak as less as possible, and in this respect, I will leave the floor to Professor Berlingieri. I mean, I will not go through his CV, otherwise we stay here for a week, but I prefer just to say Professor Berlingieri, and please.
I am going to talk about limitation of liability, compulsory insurance in the carriage of passengers by sea. Carriage of passengers by sea is governed by the 1974 Convention, recently revised by a protocol of 2002. That protocol is not in force yet, probably because it was thought that the market would be unable to cover liability insurance in respect of war risks. In order to foster ratification of the protocol, on initiative of the British and Norwegian governments, an attempt was made to find a formula that could overcome the difficulties. At the October 2006 session of the IMO Legal Committee, the text of a standard reservation and of the accompanying guidelines was adopted, with a view to reducing the ceiling of the carrier's liability in respect of death and personal injury for war risks. However, this initiative has failed to trigger any reaction until spring 2009, when Regulation EC 393 was adopted by the European Parliament. The regulation, in fact, incorporates the Athens Conventions 1992 as amended by the protocol, except its articles 17 and 17 bis on jurisdiction and enforcement of judgments. Also, the IMO reservation and the accompanying guidelines have been incorporated in the regulation. Article 12 of the regulation provides that it shall apply from the date of entry into force of the Athens Convention as amended for the community, and in any case, from no later than 31st December 2012. So we are very close to the date. Two alternatives seem therefore possible. Either entry into force of the convention for the community, and this has not happened so far, or if the convention will not enter into force by the end of this year, nevertheless the convention will enter into force and its application within the community will automatically occur. What is significant also is that the regulation applies, according to Article 2, to coastwise trade for ships of classes A and B, a reference to which is made in Directive 98/19. Ships of classes A and B, in a nutshell, are ships authorized to perform coastwise voyages in the course of which they sail at a distance of more than 15 miles from the coast. However, the application of the rules to those ships may be deferred by governments for a period of maximum 4 years from the date of entry into force. That is to say, from 2003, 4, 5, and 6. So they may postpone, and probably they will, because the application to coastwise trade may create additional problems. When the reservation applies, and it does apply in respect of war risk, the limits of liability will slightly differ insofar as carriage of passengers is concerned. The pro capita limit will be 250,000 special drawing rights and not 400,000 as provided in the Accession Convention as amended. Therefore, the global limit will affect the individual limit when passengers dead or injured are more than 1,360. I hope it will be a very unlikely event. It may also affect the global limit of the LLMC Convention, as amended, when the number of passengers of ships authorized to carry on board. So I stress the point, the number of passengers is that theoretically a ship is authorized to carry and not the number of passengers the ship is actually carrying. And the number of passengers is more than 1,920. The LLMC as amended is not in force in Italy yet, although accession to it has been authorized by a law of 23rd December 2009. And that happened owing to the failure by the government to enact the implementation rules. There was a period of 6 months to enact the implementation rules, but 3 years and a half has elapsed without anything having been done. And therefore now the government would be obliged to promote a new law extending the time limit, because otherwise it has no power to enact the implementation regulation. The delay by Italy to implement the LLMC Convention has affected the application of the Bunker Convention, which is in force in Italy, as well as of the EEC Directive 2009 on compulsory insurance, which is based, in respect of claims that must be covered and the amount of the insurance, on the LLMC Convention. With a view to implementing the directive, two alternatives were conceivable, either to accelerate the implementation of the convention, or to enact rules based on the limits of the convention and on the type of risk covered by the convention. However, the implementation by Italy of the Directive 2009 has been made in a rather strange manner, because the implementation convention, although it makes reference in the preamble to the LLMC convention, no reference is made to that convention in the text of the law itself. The problem is that the law for the implementation of the compulsory insurance provisions has been made in a way that it's difficult to implement. The problem is that the legislative decree that in question has listed the claims to which the insurance is applicable. And then at least the claims to which the insurance is not applicable. They are a reproduction of the claims subject to limitation or excluded from limitation of the LMC Convention. But after that, although stating that the insurance would apply to those types of risks, it has included two provisions that reproduce the provisions of the LMC Convention and therefore has introduced new limits of liability of ship owners under Italian law that replace the limits provided for in the Navigation Code. The limits provided for in the Navigation Code are reduced consequently to ships of a tonnage below 300 tons. So for all ships having a tonnage above 300 tons, the provisions of this Decree 111 of 2012 will apply. But the legislative decree in question did not indicate which are the risks subject to limitation, because it only says which are the risks which are subject to insurance. So there is no connection between the provisions on limitation and specific risks. And that is a question mark and creates enormous difficulties in the application of this decree. Other difficulties are created by the fact that the Decree 111 does not provide any rules regarding, to give you just a little example, of the case in which the loss of the right to limit, the right to limit is lost according to the LMC. And that creates a big problem because nobody knows how these new provisions will be applied. Which are the situations in which the right to limit is lost now? Are they those indicated in the Italian Navigation Code? They are not, because the provisions of the Italian Navigation Code apply only to ships of a tonnage below 300 tons. So for ships of a tonnage above 300 tons, there is no provision at all. And I venture to say that this is a situation in which our constitutional court would, with all likelihood, find that this legislative decree is anti-constitutional. So the provision will be really very complicated. How to remedy to this? There are two alternative ways to remedy to this gap. One is to hurry the implementation of the LMC Convention. But on the basis of the experience of the last years, when I say last, I mean 10 or 12, if nothing has been done in order to implement the LMC in 10 years, it is rather unlikely that it may be done in a couple of months. Therefore, the only practical solution of the problem would be to amend this legislative decree and to make clear that the legislative decree does not cover limitation of liability, but compulsory insurance. So the two provisions, which are, I think you have a copy of the legislative decree, unfortunately it is in Italian. I had not had the time to make a rough translation of it in English. They say general limits, the limit of liability in relation to the claims, etc., are the following. And they are the limit of the LMC Convention. So this is a provision on limitation, not on compulsory insurance. So what should be done is to change the title of Article 7, and maybe the opening lines of Article 7, so that it refers not to limitation, but to compulsory insurance. It is rather simple, and the same should be done on Article 8 that regulates the limit for passengers' claim. That should be done, and I humbly suggest, not to you, but to the government, that that should be done very quickly, because if an Italian shipowner now would be compelled to invoke limitation of liability, he would find himself in a very difficult situation. So that is something that should be considered in a hurry. Thank you very much.